What's up, Acadiana, and welcome to Offsides. I'm Shannon Wilkerson, joined with Brandon Comeaux for our Friday edition of Offsides. And it's Mardi Gras weekend. We'll get right into our first story. And our first segment today is focused specifically on DWIs. I myself am innocent. I've never had it. Of course, I don't drink.
Me too, for the record.
So that helps, okay? We are joined today by Kevin Stockstill, who's a defense attorney here in Lafayette. Good afternoon, sir.
Good afternoon. Thanks for having me.
Thought it would be a great, interesting show to have somebody who's specifically works in this field, defending people, kind of walk our listening crowd through the ins and outs of what happens if, in fact, you get pulled over, and if you are unfortunately impaired and you get arrested, what these things can cost you in terms of financial, professionally, social. You know, there's a lot of impacts now with if you get arrested. It used to be, you know, I don't want to say no big deal, but before social media, it was a completely different game.
Yes, true.
So, Kevin, tell us so walk us through what happens if you get arrested for DWI.
Well, first is the actual arrest, which is no pleasant experience. In the state of Louisiana, a police officer has the option, if you're charged with a misdemeanor, which a first offense and second offense DWI are misdemeanors, to give you a summons. But that's not going to happen. They're going to actually place you under arrest. Mm-hmm. They're going to bring you to the Lafayette Parish Sheriff's Department, to the parish jail, and you're going to actually be booked. Mm-hmm. And so,
okay, so what happens then? Okay, when you say you get booked.
When you get booked, I mean, you're basically brought downtown, you're fingerprinted. Your fingerprints go into a National Crime Information Center database, mm-hmm. and then based on your fingerprint, the sheriff's office will basically get your rap sheet.
Mm-hmm. If you have one.
If you have one.
Okay.
And so I guess it's a wonderful system for law enforcement, but for a person being booked, it takes a really long time. And so the booking process generally takes about six hours, if you're lucky.
If you're lucky. At best, you're getting out in 6 hours.
Exactly. So, that's a, pretty traumatic thing. Although you don't usually get taken up on the one of the floors at the sheriff's department, you're usually sitting in kind of the booking area.
Okay, so they don't take your clothes and give you the outfit.
No, they don't give you that whole thing, because with the DWI, most bonds are preset. So, and most people make their bond, and so.
Okay, and how much is that?
$2,500.
Okay, so you get arrested. You're 6 hours and $2,500 in the hole, no matter what.
Yeah, well, exactly. If you're paying a bondsman, or if you're going to post your own cash bond, it's going to be $2,500.
Okay. And so then you get out.
6 hours later, you get out.
Okay. If, at best, 6 hours.
Right.
Okay. So, all right. So you come up with $2,500. It's 6 hours later. And then what happens? When do you contact an attorney like yourself? Well,
you kind of need to get started relatively quickly, because time delays are beginning to run immediately. Mm-hmm. When a police officer arrests someone for DWI, they are going to issue them what's called a temporary driving permit, which is good for 30 days. They're also going to give you some paperwork, which gives you the ability to file for and request what's called an administrative hearing with the Department of Public Safety and Corrections. That's the entity that gives us our driver's licenses. Okay. The Department of Motor Vehicles is a division of the Department of Public Safety and Corrections. Right. And so before they will take your license, they're going to afford you due process by giving you the right to an administrative hearing. You've got 30 days to file for it. So that's why you kind of got to get moving, because that time delay is running. And you want to get a lawyer involved if you can, because it'd be nice for the lawyer to file that on your behalf.
Okay.
And so you want to get started pretty quickly.
And when you say it's an administrative hearing,
yes,
is that a hearing that takes place in a courthouse?
Actually, it used to. It's kind of a joke. They've actually changed the law recently. We used to be able to subpoena police officers basically to a conference room presided over by an administrative law judge for him to or her to listen to evidence and make a decision. Now they've changed it where we can no longer subpoena the police officers. And most of these administrative hearings now are handled via telephone conference. However, you want to do them, and we make it a point to usually file them, because when you request an administrative hearing, it postpones the beginning of the suspension. And so it gives you some additional time, to get your affairs in order because you're going to be looking probably at a license suspension.
So since that has been enacted of not being able to subpoena the police officers, how much would you say that has impacted cases going forward? I mean, how much of a change has that made?
Well, they certainly still go forward. I can tell you that we used to sometimes prevail in these administrative hearings. A lot of times, especially if you subpoenaed a police officer and he did not show up for the hearing, they would recall the suspension order. But now that we don't subpoena the police officers, I can say this: I haven't won one since they changed the law.
Wow.
Now we still file them because we want to get that extension, but I don't know of really any lawyers that have been successful in prevailing at the administrative, unless the police really make a big mistake in their report.
Okay.
But that's pretty rare.
Okay, so now you've got the administrative hearing. What is it, kind of sum up the whole procedure and expense. How much does this cost? I get arrested for DWI. What am I looking at in regards to a punishment and expense? Tell me everything, worst case scenario.
Well, if you're going to hire a lawyer, a private lawyer, to represent you, the going rate in this area would probably be on the low end, $1,750 to a high end of, $3,500. Maybe.
So on average, $2,500.
I'd say $2,500. If you end up going to trial, you could get up to $5,000.
Okay.
And so
and why would so if you had an argument, if you thought that you were arrested, wrongly, that would be that would be an event where you would go to trial.
Right. And just as an example, the last one that I tried, most of the Lafayette City Police Department has a kind of a special unit called ATAC, where these are law enforcement officers who basically specialize in detecting impaired drivers. I know for all of those officers, they have dash cams. And so when they're going to do a field sobriety test, which is one of the tests that they're going to perform to try and determine whether or not you're intoxicated, that test is in the field is going to be videotaped. Okay. And so also when they bring you to the Lafayette police station, for you to submit a breath sample, if you decide to do that, what's going on in that room is videotaped as well. And so, we've potentially have some good evidence. If I look at a video and I see that my client has performed well on the field sobriety test, that's an example of a case that we're going to potentially try to a judge.
All right.
Some clients don't take any of the tests, and
well, that's a good point. What can you refuse the test?
Yes.
Okay, and can they arrest you if you refuse the test?
Yes.
Okay, and what's the charge?
Suspension of driving under the influence. Because when a police officer gets to the field sobriety test, I mean, he's, should be able to articulate that he has smelled alcohol on your breath. There was maybe some erratic driving. It only takes probable cause, which is a very, very low standard to arrest someone. And so if you have every right to not participate in the field sobriety test, you have every right not to give a breath sample. But generally, the police are going to arrest you when you refuse those tests because at that point, they believe that they have at least enough to arrest.
Okay.
So I've got a couple questions for you. First off, let's go, since we're talking about the police side right now, I just want to ask you the simple question because every time we put out a news story about sobriety checkpoints, especially, here within Lafayette Parish, I mean, the police will let people know ahead of time, hey, we have a sobriety checkpoint, unnamed place in the parish. We put that out. There's always a discussion that breaks out over our Facebook page or whatever of people saying, well, this is not constitutional. Can you answer that question? Are sobriety checkpoints constitutional?
I believe they're unconstitutional, but no one's really listening to me. I'm a criminal defense lawyer. I'm at the bottom of the totem pole here, But the United States Supreme Court, which we all have to listen to because they pass decisions that become the law of the land. They say it's constitutional, and so at this moment in time, they are. And if you find yourself being arrested after having gone through a checkpoint, your lawyer is not going to be able to make an argument that the checkpoint was unconstitutional.
Okay, well, going back to what I asked you a moment ago, we'll apply the same type of a question. If you get stopped at a checkpoint, okay, do you have to roll down what happens if you pull up and they shine the flashlight? Could you roll down your window, please? We want to see your driver's license, speak to you for a moment. And you just flat out say, no, I'm not rolling down my window. I'm not rolling down my window, and I didn't do anything wrong, and I want to go home.
Okay. Well, you do have that right. The Fifth Amendment to the United States Constitution grants you that right. You do not have to answer any questions. You do not have to engage in conversation with a law enforcement officer. What an officer would do at that point, I don't think you're going to be allowed to leave. It could escalate to the point where they may forcibly remove you from the vehicle.
Okay, so they could break your window and pull you out.
It's possible, you know. I would think that I guess a middle ground would be to maybe roll down the window and inform the police officer that you're not going to answer any questions, and that you're invoking your right to counsel and your right to not make a statement. Okay. And once a person invokes their right to counsel, our law says that stops any and all questioning at that moment.
Even at that level. Even at a checkpoint.
Yeah.
Wow.
Because if any conversation, if the police officer were to continue to engage you in conversation and he learned something from that conversation,
can't use it.
It's possible that statement would not be used in court or could not be used in court.
We're speaking with defense attorney Kevin Stockstill here on Offsides, Brandon Comeaux, Shannon Wilkerson. And we're talking DWIs, and we're really doing this to make sure that you know the potential harmful, repercussions that could come as a result of drinking and driving, especially during this Mardi Gras season as we're on the upcoming weekend. I want to ask you about DWIs, and that we'll get stories every now and then that will come out where someone will have 5 getting arrested on their fifth DWI. And again, it's another type of story that causes, outrage and conversation amongst the listeners. Explain for us, especially as a defense attorney, how does that happen where you can have somebody get arrested 5, 6 times for DWIs and yet they're still out on the streets driving? I mean, it's not even at the least 1, 2, 3 strikes you're out, but you've got people that continually get these arrests. How do they continue to be able to be allowed to be on the roads? I mean, we know police officers have to do their jobs to put these, to arrest these people, but then the court systems are obviously letting them go. How does that happen? Louisiana law, how different would it be compared to across the country?
Not sure about the rest of the country, but we do have part of our law says that the prosecution can only use convictions that are older than 10 years to enhance a charge. And so a DWI is an enhanceable offense, which means, the first one is a misdemeanor. The second is also a misdemeanor, but it carries some mandatory jail time. Third is a felony. Fourth is a very serious felony, which carries a minimum 10-year sentence. But what happens sometimes is you'll have people that over the years have accumulated DWIs, but the prosecution can't go back and use some of the prior DWIs because they're too old.
Oh, wow.
Okay.
And so
that's interesting.
Yeah.
So you could have a person who's had 5 and 6 over a lifetime, but they could only potentially be charged as a second offender because 3 of those priors are too old. Wow.
Yeah, and so, what I see, what I have seen with customers and friends, people that I know, is that it's becoming more common that after the second offense they have house arrest.
Yes,
I see a lot of people that are sentenced to house arrests and such. So,
and it kind of depends too. Sometimes your case will go to city court if it's investigated by Lafayette City Police. If it's sheriff or state police, it's going to go to district court. And so, I find city court is a little bit more strict and strenuous on their sentences than some of the judges in district court. So
wow.
Anyway, I guess the bottom line is it's a very expensive proposition. It is not a fun experience. It's so much cheaper to just call a cab, park the car, get an Uber app, catch an Uber ride home. It's really not worth it. It's not against the law to drink. It's certainly not against the law to drive. It's just against the law to do both. So drink, stay home. If you're going to go out, Uber, get a designated driver, catch a cab. It's just not worth it.
Great. Thanks for joining us today. A lot of great information.
Thanks for having me.